individual for the 5th District, State of Florida is now in session. Now, William P. Palmer, Chief Judge, presiding. All persons business for this court, Your Honor, you give attention and you shall be heard. Give God save the United States of America, the State of Florida, and this honorable court.
Good afternoon and welcome to an oral argument session of the 5th DCA. Let me begin by introducing the panel. As you've heard, I'm Judge Palmer. To my right is Judge Zawaya. To my left is now Senior Judge Thompson. The court, after issuing its opinion in this case and receiving the motion for rehearing, decided sua sponte that it would be helpful for us to hold an oral argument in this case. We talked procedurally how we wanted to do that. We are going to proceed as we would with an oral argument before an opinion was issued, so the appellant will go first. You are not necessarily limited to the specific issues in the motion for rehearing because we want to be able to explore all the issues in the case. The appellant will have 15 minutes and can save as much of it for rebuttal as you would like.
Good afternoon. I am Tom Luckashaw from the Public Defender's Office, representing the appellant, Mr. BERUBE. And it is our position this afternoon that the opinion issued by this court is the correct opinion, the correct decision, and should not be withdrawn by this court. The facts in this case, in our opinion, and correctly viewed by this court, were that the conduct by Mr. BERUBE in driving the minivan on the highway that day and making the left-hand turn did not amount to more than mere negligence. It did not rise to any...
Does the record tell us, one of the issues that has bothered me just a little bit is why would he make it seems to me, if I recall the facts of the case, he was in the right-hand lane. I think the dump truck may have been behind him. He moved over into the left thoroughfare lane, and there were two lanes of traffic with the left the left light red, and so they were waiting for the light to turn green. So apparently Mr. BERUBE was in the right-hand lane, followed by the dump truck some distance back. He switched over into the left-hand thoroughfare lane, and then, according to what's in the record, suddenly stopped. And at first, when I read the record, I thought, well, he would have done that if he was trying to get into one of the turn lanes, and perhaps they were crowded. But I'm trying to discern what exactly does the record tell us, if it tells us anything about why he may have stopped. Does the record tell us that the two left turn lanes were crowded and there wasn't any room for him? Where, in relation to the first car in the turn lane, did he stop? Was it next to the first car in the turn lane, or was it some distance back? Can you tell me what the record tells us about that?
Your Honor, I'm not sure that the record is clear on that. I do agree with your recitation of the facts that he did move over from the right through lane to the center through lane, and there were two lanes there for left turns to be made, and the lights were red. And I'm not exactly sure where he did stop.
Is there any testimony or evidence in the record as to where in that left lane he may have stopped vis-a-vis the cars in the turn lane right next to him?
I don't know the answer to that question.
The record doesn't tell us that. Okay,
I don't recall that being in the record, where exactly he stopped in relation to the cars that were in the left turn lane.
Okay, is there any evidence in the record that he may not have made a complete stop, but slowed almost to a stop?
Yes, his wife did indicate that he never did.
Besides his wife?
Not that I recall.
Okay. So what we have in the record is that he pulled into the left lane. There were two lanes of traffic next to him that were waiting to turn left. That left signal was red, and he made a stop. There was the truck behind him. And I think the evidence is pretty clear that the truck initiated its brakes. There was evidence from a witness that white smoke was coming and blue smoke was coming, and the truck was honking its horn. And it essentially stopped about 2 feet before it got to Mr. BERUBE's car.
That's my understanding also.
And one of the things that's troubled me is that the testimony was that when the dump truck came to a stop, eventually came to a stop. There may have been a very short interval, maybe 2 seconds, and then Mr. Berube took off and made his left turn.
That
And
is
that's-
possible, yes.
Well, doesn't the record tell us that?
Well, apart from the wife saying that they never stopped. I mean, I, of course, don't know what happened, but the facts in the record would support that, but also there was contradicted by the wife's testimony that he just slowed down before proceeding to make the left turn.
And there's nothing in the testimony of the evidence that would tell us why he did that?
No, we do not know why he stopped abruptly in the through lane. But even assuming, for whatever reason he stopped, it's our opinion that it does not amount to more than mere negligence. We don't know why he made the stop, but once he did, this truck behind him, as you indicated in the facts reveal, slammed on the brakes, probably a lot of noise, smoke, and according to the wife, he panicked at this point. Now, if he proceeded to go straight, he might not have believed he would have been able to get out of the way because of the forward momentum of the vehicle behind him. And of course, in that situation, probably very difficult to make a judgment whether or not there's going to be a collision or not. Looking in a rearview mirror isn't always a reliable indication of how far a vehicle is behind the vehicle you're in. So he apparently panicked, probably with his children in the backseat, apparently felt that making a left-hand turn was the safest course of conduct at this point to get out of the way of the vehicle behind him.
How do you distinguish this case from the Nocencia case, the fog case?
Well, if there was a dump truck barreling down on the vehicle that passed in the fog, I would say that would be a similar case. The fog case, it would seem that there was more of a deliberate decision to pass the vehicle in the fog, probably contemplated it. We don't know how long behind the vehicle he was trailing that he waited before making that decision, but certainly there seems to be more time for reflection on before making that decision to pass in the fog. However, had there been a dump truck coming behind him and it looked like there was going to be an imminent collision, and then he passed got into the left lane to pass the vehicle to get out of the way, we would have a situation similar to this case.
Does the Nocencio case, is there a reason to distinguish it because that was a case that was based on a motion to dismiss the information as opposed to looking at a jury verdict and looking at all the evidence? I believe the Nocencio case was a dismissal, wasn't it?
Yes, pre-trial.
Is there a reason to distinguish the case based on that?
Well, the standard was where the state made a prima facie case. I mean, if they went to trial, the state would have to prove those facts. Prior to trial, the state, they were just deemed to be true. And the judge in that case felt that the state, I don't recall if that was dismissed, yes, that the state didn't make their case.
But obviously, if they ultimately proved whatever was in that complaint, it would have survived
It would have
judgment
survived.
of acquittal, right?
Yes. It would have survived a judgment of acquittal. But again, I think the distinguishing factor is we don't have this emergency situation that we have in this case. Certainly there's more time to deliberate and reflect on the conduct. Probably it was just impatience on the driver's part that he wanted to get around this vehicle, and certainly that would be reckless under those circumstances. But in an emergency, that may have been his only his only option would be to pass the vehicle in front of him.
Well, of course, one of the problems with that is if we take the facts in the best light to the state, which we have to, correct?
That's correct.
The emergency was over because the truck had stopped, right?
Well, that would have, again, we don't know what Mr. BERUBE perceived at that time. There was apparently a lot of noise and racket in the car. He may not have perceived that the truck did stop. And if his wife is screaming at him that our kids are going to be killed, he probably just slammed the pedal to the metal and took off, thinking that a left-hand turn was probably the safest course of conduct. So actually, it appears he was acting for the safety of the passengers in his vehicle. And under those circumstances, we cannot say that it was likely that he knew that there would be death or great bodily harm by crossing the other lanes of the oncoming traffic.
The language of most concern to me in that case is it is sufficient that he intended to drive as he did. Is there any question in this case that he intended to drive as he did, even if he was under emergency circumstances?
I would agree that he intended to make the left-hand turn, but in that situation, did he really have an option if he was considering the safety of the passengers, including his children, in the vehicle? I mean, yes, he intended to. Otherwise, I mean, the vehicle doesn't operate by itself, and he certainly steered it into the left turn lanes and into the oncoming traffic. In that sense, it was intentional, but again, his options were very limited at that time. So, yes, I would agree, we could see that it was intentional in that sense, but we don't think it was any wanton disregard for the life of others, and that he could not foresee that it was likely that death or great bodily harm would occur because of his conduct. Of course, it's always possible.
Why is that? I mean, explain to me why it's any less predictable when you cut across 3 lanes of ongoing traffic against the light than, for example, in this case, passing in the fog, not knowing if there's somebody coming at you.
Well, the distinction I would make is that again, under the emergency circumstances, and the statute for an improper left turn is only a civil infraction. I mean, of course, in any circumstance, and again, I think the state's approach is result-oriented in that any time there is a tragedy and a traffic infraction, after the fact, it's easy to foresee that result. I mean, you could probably present any traffic infraction scenario, and somebody in this room likely to be able to come up with how some tragedy could occur, and you could say, yes, I can see how that's foreseeable. You know, it's always easy to see when somebody has a brilliant idea to say, yes, why didn't I think of that? I mean, after the fact, it's much more easy to foresee something when it's actually hindsight. But under these circumstances, just merely making a left-hand turn, I mean, it's very possible and maybe quite probable that he could have safely gone over 3 lanes of traffic without a problem at all. I mean, it's just not absolutely...
Now, do I understand the layout of this being that he would have basically gone left and gone through 5 lanes, 2 left turn lanes, and then 3 lanes of traffic from the other direction?
I would count it as, well, the 2 that, in his direction, the 2 left turn lanes apparently in the opposite direction, plus 2 more, so I guess that's 6 lanes of traffic. Okay. But 2 lanes were already, we know 4 of the lanes were stopped at the red light. They were... The left red arrow was stopped on both lanes, so 4 of them were stopped. So actually he was crossing...
So the two turn lanes going away from him and the 2 turn lanes... Right, they apparently had the reds and there's no vehicles. It would have been the other 2 that were stopped.
So it was only 2 that he would have to worry about.
Now, do we know whether when he crossed across his 2 turn lanes, they were now full or empty? Were they still full?
I'm sorry, the cars that were stopped...
Yeah, when he made his left turn, the first 2 lanes he crossed, which were the left turn lanes, they were still full of cars, presumably?
Yes, I believe they were. The truck driver said he was obstructed.
Right, okay.
Yes.
So he would have cut across lanes with cars in front of him, which would have obstructed the view, so he didn't know what was coming after.
Well, that was the truck driver's opinion, that they were obstructed, and he was perhaps had a better vantage point, but yes, I don't know.
Now let me ask you this then, as I think about the outline of this intersection. If there was enough room in the 2 left-hand turn lanes for him to be able to get between the cars, okay?
Yes.
He could get out of danger without ever crossing over into the oncoming traffic, right? A car is not wider than 2 turn lanes, is it?
Right, but if he had hit the pedal to the metal and just accelerated and then made an abrupt stop, that would have been dangerous to the passengers in the vehicle also. So again, in this situation, emotionally charged situation, it's hard to know exactly what he was confronting at that intersection. And we don't think that the result was foreseeable, or nor was his conduct wanton. He did not have a conscious and intentional indifference to the consequences, other than he wanted his passengers to be safe. And I would like to reserve my remaining time for rebuttal.
You got about 2 minutes.
Thank you.
May it please the Court, my name is Ann Phillips. I'm here on behalf of the State of Florida. It's the State's position that the trial court properly denied Mr. Berube's motion for judgment of acquittal. The evidence was sufficient to surpass...
Let me ask you, do you see a difference, a distinction between a case where an individual is traveling down a two-lane highway in the fog and can't see, and there's really no reason no emergency reason that would compel him to pass in the fog other than he was in a hurry and just wanted to get out from behind the car in front of him. Do you see a difference between a situation like that and a situation like the BERUBE case where let's say, for example, we exclude the testimony of Mrs. BERUBE that there was hollering and screaming and panic in the car. We have the testimony of the truck driver, and there was another individual that testified, I believe, in one of the turn lanes that saw what happened, and they testified that the dump truck slammed on the brakes. There was white and blue smoke billowing from the tires. He was on his horn honking and was barely able to get the dump truck stopped 2 feet beyond the back end of Mr. BERUBE's car.
Correct.
And I think that it's logical to assume that Mr. BERUBE knew all of this. If the driver in the left-hand turn signal heard this and saw it, Mr. BERUBE did too. Correct. And so he observed a situation where he thought that the people in his car were going to be injured by this dump truck. Took off and tried to take evasive action. Do you see the difference factually between this case and what we refer to as the fog case, the Inocencio case?
Factually, obviously, they are distinguishable, but I believe that the way you relayed the facts omits a very important factor, and that's that Mr. BERUBE stopped on a green through light and created that hazardous situation. I don't believe he can now bootstrap himself into saying, I created a hazardous situation, and to get myself out of my own hazardous situation, I'm allowed to take whatever actions I see fit for my car.
Right. The question then becomes, was it willful and wanton when he took off from that situation and tried to avoid what he thought was a perilous situation for the people in his car, and tried to avoid that, and did what his opposing counsel indicated, took a left-hand turn to try and avoid a bad situation for the passengers in his car.
Right.
And so I guess in a situation like that, the question then becomes, is it willful and wanton, as opposed to someone passing another vehicle in the fog simply because they were in a hurry and wanted to get around the car?
Absolutely.
Isn't there a distinction, a difference between the two cases?
I think it's a distinction without a difference, respectfully, Your Honor.
Is your argument that anytime there's a traffic violation and a death, it's egregious enough to be manslaughter?
No.
Or vehicular homicide?
Absolutely not. I believe in this instance it is.
Well, that's a case-by-case analysis, and what troubles me about this case is, but for the death, what would be the ticket that could be issued to Mr. BERUBE?
Failure to yield, crossing against a light, stopping in a green through lane. I don't know if he used his turn signal, reckless driving.
Well, from the record,
That he improperly stopped on a green light in a thoroughfare. He failed to yield to the traffic that was oncoming.
Are all of those things that you mentioned indications of reckless or careless driving? Are they traffic civil infractions, or are they county misdemeanor violations of the Florida statutes?
They're civil traffic infractions.
Well, in order to reach the element of vehicular manslaughter, one of the most important elements is that the egregiousness of the driving or the behavior, that it's reckless driving.
Correct.
You would argue that a traffic civil infraction with a death is enough to elevate it to a vehicular homicide. Is that your argument?
Based upon the facts that we have in this case, yes, Your Honor, that is my argument.
Well, then your argument would be anytime there's a civil infraction and a death, it's a vehicular homicide?
It would depend upon, sometimes an accident is an accident. That's not what happened. This was avoidable on many, many levels. And based upon his conscious and intentional driving, he intended to drive the way he did regardless of what happened.
If I intend to not remain stopped at a stop sign, and I do a New York or California road, and I don't come to a complete stop, and someone dies, is that then a vehicular homicide because I failed to remain stopped at a stop sign?
I'm going to have more facts. And I
Fact
have
is,
all the
I
facts
rolled
here.
through the stop sign and hit someone and they died.
If it is reasonably foreseeable that you intend to drive and you know that with knowledge that could be a consequence, that you could run straight into this person and kill them, then yes, it could be.
Well, here's a problem I am having. You seem to want the result to determine the factors that would lead to either reckless driving or the elements of manslaughter. Every time you get in a 3,000-pound vehicle, if you don't have proper tires or if your lights are not working properly or your turn signal, and someone dies as a result of your inattention to detail, is that then a vehicular homicide because you knew or should have known that there could be a death because of the weight, size of your car, etc.?
If you have acted under the law with a conscious and intentional indifference, then yes, that is what the law states.
How can you act that way when you are trying to avoid an emergency situation where a multi-thousand-pound dump truck is bearing down on you, the horns are honking, the brakes are locked, white smoke coming out, and Mr. Berube sees this, and assuming that the wife and the passengers in the back seat, I can't foresee that they could help avoiding it. How could that be reckless indifference to the life of others when he had no alternative but to get out of there and try and avoid that situation?
Because there was testimony that hazard had stopped. He stopped the car for 2 seconds, and then Mr. Berube proceeded to turn left, not to go straight, not to move into the 2 left-hand turn lanes that were next to him, not to pull into the median, not to stop in front of the left-hand turn lane in the oncoming traffic, but to go ahead and make his turn all the way through oncoming traffic in a through lane.
But the stop, I think he stopped a couple feet behind the car, and the testimony was there may have been a short period of time, maybe 2 seconds.
Yes.
And so Mr. Berube or a driver in that situation is supposed to be able to discern in that short period of time that a truck that stops that short a distance between his bumper is not going to continue to be a hazard and sit there and see what happens?
I would have expected Mr. Berube, the moment he heard the squealing tires, to go straight, to gun it and go straight, the way that the green light was. Not to say, well, I'm going to get myself out of this and go the direction I wanted to go.
Was there evidence that the through lane that he was in was clear in front of him?
No, but there was no one in
Or whether
front
he
of
had
him.
the option to go straight?
He would have had the option to go straight because he was the next car in that lane to go straight.
It was still a green light?
Correct.
Do we know that?
Yes.
All right, so and there wasn't any evidence that he came to a stop because anybody in front of him was stopped, correct?
He
So
stopped.
there would be an indication
wife-
that there's space in front of him to go straight if he
Correct.
wants.
His wife testified he stopped because he missed his turn. They wanted to go that way. That was the direction they needed to go. His wife had him stop. This court has to view the facts in the light most favorable to the
I
state.
agree with you, but let's get back to the law for a moment. The behavior of Mr. Berube before the accident which caused the death, was that careless or reckless driving?
I'm not sure. His changing lanes from the right to
His
the
behavior in
left?
driving up until the time of the collision, was that careless or reckless driving?
Reckless.
Why? What
Because
elements would you
he
say?
has got a green through light in a busy intersection that's with traffic going 45 to 50 miles an hour, and he stopped for no reason. He did
So
not
if
have
you
car trouble. He did not. He chose to create that situation because he wanted to do something different.
So if you're driving and a tourist is driving, looking at the map and stops in a throughway, that's reckless driving in your opinion?
Depending on what the traffic conditions are, absolutely.
All right.
Now, in the fog case, would the violation that driver would be subject to, would that be just a civil traffic infraction as well, rather than a criminal misdemeanor?
I think that they were, which action?
In the fog case?
Right, when he went
Where he
around.
found it was sufficient to go forward, where he passed in the fog, not knowing if somebody was coming towards him.
That was
Asking the
reckless.
same sort of question, Judge Thompson.
Yes.
In that case, if there were no death, what would the
That would be
charges
reckless
have been,
driving.
and would that have been a civil traffic infraction?
That would have been a reckless driving charge as well, I believe.
Reckless?
Yes.
Instead of improper change of lane or passing without warranting the conditions?
Yes, based on when you have to put all the inferences together.
Well,
Not
the
one
fog case is simply he passed and it was fog and there was a death. That's it. No alcohol, no excessive speed other than the passing. That's all we know from the record or from the opinion. That's all we have.
Right, and in the same instance, when this court said such a driver is gambling on an empty highway with potential death as the stakes, Mr. Berube was gambling on no through traffic with death as the stakes for anyone that was coming on who couldn't see him, who would certainly not be expecting a left-hand turn from a through lane.
Absolutely. Are you familiar with the definition of reckless driving is compared to careless driving?
To give you a specific, no, I don't have it written down. I don't believe we
No, I'm
cited
asking
it.
the definition. Are you familiar enough to know the distinction between a careless driving and a reckless driving?
I believe the recklessness involves the conscious and intentional indifference, whereas carelessness means that you just simply aren't aware. You don't necessarily have a conscious indifference to it. You may not think, you may not know that there is a blind turn, that there is fog, that there is...
If you read the
oncoming traffic.
definition of careless in the fog case, and that was careless driving, not reckless, absent the death, would that change your opinion as to the facts of this case and how it should be treated by this panel?
I don't believe so.
So the definition would not be of concern to you?
The definition would be of concern to me. I believe there is a difference between carelessness and recklessness.
Would you give the facts? In your brief, you mentioned that it was a clear day, that it was dry, the visibility was impeded. Are those the only factors in your mind that would elevate it to reckless and then to vehicular homicide?
No, I don't believe so. I believe that because Mr. BERUBE created the situation.
By stopping at
By
the green
stopping.
light?
He created that. He made that dump truck do what it did. He created the own fear in himself. He put himself in a hazardous situation. And much in the way we don't allow other defendants to bootstrap their own defense, that's exactly what he's doing here. He's trying to create sort of a coercion.
Right. Let me offer one hypothetical to you. Suppose a woman is operating a vehicle while using a cell phone, and as a result of her inattention kills 2 children. Is that vehicular homicide at the max or at the least reckless driving?
I believe it would be. A lot of states have made that rule. Absolutely. It's not here currently, I don't believe, but certain states have made it reckless because you are now
That would be reckless,
choosing
yeah.
to be on the phone rather than having your full attention on your driving. There are states that have made it that. Florida is not
Well,
one
what
of them.
about Florida?
Florida
We're only
has not
talking
done
about
that.
Florida.
No, Florida has not done that. So here it would not rise to the level
So
of
even though the
recklessness.
death was caused by being inattentive, driving, let's say running through a stop light.
Well, now you're adding new facts.
Well, that's why I'm giving you an opportunity,
You want to add some new facts?
Yes,
Absolutely.
yes,
I think it
yes.
can rise to the level of recklessness, yes. I think you would have to look at what your totality of the circumstances were.
Those, I will not add
Absolutely.
any more, but if in that case it was not a vehicular homicide, would that change your opinion on this fact?
If there was an opinion out that said that all...
There was no citation issued.
I would have to argue that that would have been incorrect, but I mean, if I had had that option, yes.
In this case, if the defendant was stopped at a red light, and the same thing happened for whatever reason, the dump truck doesn't see him, or it's not stopping, and it slams on the brakes, and the exact same thing happens, and then he whips across the lanes, would that be sufficient to get to the jury?
I don't believe it would be.
So the fact that he helped create the emergency makes a difference?
That absolutely, it makes a huge difference. And again, you're looking at the facts in the light most favorable to the state, where that danger had been erased because that car had stopped for up to 2 seconds. And to answer Judge Sawaya's first question, on page 46 of the record, Mr. Coons, who was in the turn lane, stated that he couldn't see whether Mr. BERUBE had a turn signal on or not because he said the vehicle was almost beside me. So he would have been behind the stop line, it appears, or almost even with the first cars in those turn light before he went.
You familiar with the Del Rio case out of the 2nd DCA?
No, I don't believe so.
Briefly, in that case, that was involving a T intersection, opinion written by Judge Aldenburn, similar to this case, where they found that the court properly did not allow the case to go forward to the jury because it did not have all of the elements sufficient to be reckless, therefore vehicular homicide. And is your argument simply that it's a case-by-case situation, that if the facts are there's a traffic civil violation and a death, that's sufficient to cause a vehicular homicide to properly lie?
I can't say in every case. I think you're going to have the state attorney's going to look at that on a factual basis, looking at all of the facts that surround a case. So to make a blanket statement, I'm unable to do that. But the jury here went and viewed the intersection.
Right.
They heard the evidence. They determined the credibility of all these witnesses, and they came up in favor of guilt. The trial judge properly denied the motion for judgment of acquittal because the state put on a prima facie case. We ask that you uphold the jury's verdict.
Thank you, counsel.
Thank you.
Unless the court has additional questions, I'll waive my remaining time.
Let me ask you what relevance, if any, you think there is to whether or not the original emergency situation was caused by some wrongdoing on the behalf of the defendant. Would it make any difference in my hypothetical if he was sitting at a red light and this truck was bearing down on him?
To me, it doesn't make a difference. Because I don't think that he had the foresight to know that the truck was going to be slamming into him at that point. I see the distinction that the state is trying to make, that he created this situation, whereas if he was properly stopped at the light and then proceeded due to the emergency.
And do you agree that the record would support the proposition that the lane in front of him was open, so he would have the option of going straight as opposed to cutting across the...
Even if he had the option to go straight, the forward momentum of the truck behind him, it would be hard to judge once he stopped if moving forward would be sufficient to get out of the truck's way. I mean, it would be very difficult for a person looking in a rearview mirror to be able to tell how far forward you have to go from a standing stop position in order to get out of the way of a vehicle that's about to collide with your vehicle. So I don't think that's relevant whether or not there were no cars ahead of him blocking his forward progress if he decided to go straight ahead. And that's why I think a left turn was the only option for him to get out of the way. And I would just remind the court, in our initial brief, we said to the Esposito case where a bus driver was inattentive just for a moment, looked away from the street, and then hit a woman who was crossing the street, an elderly woman, and the court found that that was just mere negligence in that case.
The argument in that case, it was a trolley, and yes, there were no other exceedingly egregious factors, as has been listed by the state, stopping, crossing several lanes of traffic, etc.
That's true, but it just goes to show again that the result cannot determine whether or not the conduct was willful or wanton. And again, we don't believe in this case that the conduct by Mr. BERUBE rises to the level of recklessness. He did not have a disregard for the safety of others in this case. He was concerned for the safety of the passengers in his vehicle, and in his mind at the time, it appears that that was the only option he had to avoid a collision. Thank you very much.
Thank you both. Well argued on both sides. Thank you.
Be in recess.